Here are the top 3 ways to avoid probate. The best option is with a living trust. A living trust is called a living trust because of its convenience. The term living has no legal meaning to it. It just is meant to connote that it is a convenient way to leave your estate because it's amendable and even revocable. In addition, trusts do an amazing job protecting your beneficiaries, and they keep the costs of the administration of your estate way down and make things way simpler. There's just a lot of advantages to avoiding probate with a living trust. That's the number 1 option that you should know about. The next most common option for avoiding probate is through joint tenancy. Now, joint tenancy, by operation of law, will pass to the surviving joint tenants, whoever they may be. You can have multiple joint tenants, or you can have, in most cases, one other joint tenant, which is going to be a partner or a spouse or a parent. Joint tenancy can apply to real property. It can apply to bank accounts. It could even apply to other assets like a car or something like that. But there are some drawbacks to joint tenancy that you should be aware of. Firstly, if that asset has any taxable basis, the surviving joint tenants won't receive a step up in basis. This is a particularly big thing to know about for real property and brokerage accounts. You shouldn't ever put a child as joint tenant on either of those things because the step up in basis is going to be lost, and that's potentially 6 figures or more of taxes that you would avoid in capital gains taxes. Additionally, putting someone else as joint on your bank account or on your car or house makes them legally a title owner to that property, subject to their creditors' claims. Ooh boy, a creditor claim, you don't want one of those, especially if it's not your creditor. Let me say that again. If you put someone else as joint tenant on your jointly held asset like a house or a bank account, it's going to be subject to another person's creditor claims. So don't do it. If you can't afford to lose it, don't risk it by putting someone else on as a joint tenant. All right. That rule works just as well for gambling as it does for managing your estate. All right. Finally, the last way to avoid probate that I'm going to talk about is pay-on-death designations. Pay-on-death designations are an agreement with the custody of that account to pay the proceeds to a named individual when they furnish a death certificate to the institution. It's a nice, convenient thing to do, especially if you just have one beneficiary and you don't want to go to the rigmarole of setting up a trust. A pay-on-death designation on your bank account, a transfer-on-death designation on your brokerage account, and a transfer-on-death deed or a will in Virginia is a solid recipe for avoiding probate that we will recommend in cases where it's appropriate, according to what I call the narrow set of facts, where your intended beneficiaries are all adults, they have no special issues, and they all get along. In that case, I think that avoiding probate without a trust is a value proposition that is going to work. Reach out to us if you want help with that. So why do we talk about avoiding probate so much as estate planning attorneys? Well, it has mainly to do with the time and the expense involved in performing probate of an estate. On the inside track in Virginia, probating an estate takes 16 months from the date of qualification, which could be years or months after someone dies. So you're looking at not being done with the estate until at least 2 years after someone's died in many cases. Then there's also the costs of probate, paying the court for the privilege of being supervised, and the probate taxes, 1/10% in Virginia, not the end of the world, but still a cost, and just the raw time if you're going to attribute a dollar value to that. And if you're going to hire an attorney, then they're going to measure their dollar value in time. So there's cost there as well to consider if you need to hire an attorney to administer that estate in probate. And so avoiding probate turns out to be a gift to your beneficiaries. I say that it's an act of care and compassion towards your loved ones. Doing these things in advance so no one has to pick up any messy pieces is really a gift of care and compassion towards the ones you love. If you need any additional help with any of that, please reach out to us at Speedwell Law. Thanks. Have a great day.